Sometimes, criminal proceedings are brought in 2 or more EU member states against the same suspects and in relation to the same facts. This is known as a conflict of jurisdictions. It can also arise if the facts aren't the same in each case, but the cases are mutually dependent. It's a widely established legal principle in Europe that a person can't be punished twice for the same offense, even in different member states. This is known as the ne bis in idem principle. When parallel proceedings arise, decisions need to be taken about which member state is best placed to prosecute and try the case. Occasionally, a negative conflict of jurisdiction arises when no member state has the competence or capacity to prosecute a criminal offense for different reasons. These are especially difficult cases. And when a conflict of jurisdiction is identified, identifying the member state best placed to prosecute and transferring criminal proceedings to that member state can create legal and practical challenges. Criminal law jurisdiction is a complex issue, and member states have different legal systems and procedures. As a result, there are no common procedures for transferring criminal proceedings to another member state. Nevertheless, the EU legal framework places Eurojust at the heart of national efforts to prevent and resolve conflicts of jurisdiction and to facilitate the transfer of proceedings. Eurojust serves as a coordination platform for its national members to meet, discuss, and agree the way forward in these delicate cases. They can agree on a solution and issue a joint request to their national authorities concerning which member state is best placed to prosecute. This helps national judicial and law enforcement authorities in their own decisions and actions. And in rare situations when national members can't resolve the situation among themselves, the Eurojust College can intervene. It issues a written opinion on which state is best placed to exercise its jurisdiction. When it comes to the transfer of proceedings, Eurojust assists with legal issues and formalities, facilitates paperwork, and offers national authorities a framework for rapid resolution of cases. Where operational costs become an issue, such as for translation of case files, Eurojust facilitates agreement so that procedures can move quickly and effectively. In cases where risks of bis in idem arise, Eurojust helps member states to detect and resolve conflicts at an early stage. The agency does this by clarifying whether the facts under investigation in 2 member states are the same and verifying whether a judicial decision is final under national law. With wide experience of managing and resolving conflicts of jurisdiction, Eurojust makes its best practice available to national authorities. The agency's guidelines for deciding which jurisdiction should prosecute help identifying what factors to consider when deciding which state is best placed to prosecute and prevent criminal suspects from avoiding justice or being prosecuted twice. A wealth of information and expertise in relevant case law enables Eurojust to advise stakeholders on the application of EU and relevant international law on conflicts of jurisdiction and ne bis in idem.